From children's programs to in-depth documentaries, SDPB sparks curiosity and lifelong learning in every South Dakotan. SDPB. Good, useful, and full of wonder. SDPB brings South Dakotans together, telling the stories that unite small towns, big ideas, and the people who make our state shine. Good, useful, and full of wonder. SDPB. SDPB shares the voices and experiences of South Dakotans, preserving our stories, our culture, and our sense of place. SDPB, good, useful, and full of wonder.
Good morning, everyone. Welcome to Senate Judiciary. I'd like everyone to please take a seat, turn your phones to silent. If you plan on testifying today, please make sure to sign in the back of the room if you haven't done so. It's an electronic system now. If you're testifying and have handouts, please have the pages distribute them to committee members. They're on errands now, but they'll be back soon. Lobbyists, please make sure you're wearing a badge and the badge is clearly visible. Welcome to those joining us online. If you do need to contact us, our committee contact is senatejudiciary@sdlegislature.gov. And lastly, a reminder that all testimony and all questions should be addressed through the chair. At this time, I'd ask the secretary to please call roll.
Senator Blanc.
Here.
Duhamel.
Here.
Grove.
Here.
Melhoff.
Here.
Pischke excused. Hulse excused. Kolbeck excused. Mr. Chairman, we have a quorum.
Thank you. The chair would entertain a motion to approve the minutes of the previous meeting. It's been moved by Senator Grove, seconded by Senator Blanc to approve the minutes of last meeting. All those in favor will say aye. Aye. All those opposed? Minutes are approved. Okay, we'll introduce the pages when they come back. We're going to follow along to the agenda, and starting with House Bill 1164 to establish a crime of fraudulent assisted reproduction and to provide a penalty and civil liability thereof. Representative Jorgensen, welcome.
Thank you, Madam Chair and members of the committee. I'm Representative Terry Jorgensen, District 29, and HB 1164 establishes the crime of fraudulent assisted reproduction and provides for both criminal and civil remedies. I first became aware of this issue when I stumbled across a YouTube video featuring fertility fraud that led me to watch a Netflix documentary called Our Father, which details how an Indiana doctor, fertility doctor, used his own sperm to inseminate patients without their knowledge or consent. To date, he's fathered over 90 children. Similar cases have occurred across the country with at least 50 providers accused. One provider has ties to South Dakota. States like Indiana and Texas have passed laws specifically addressing this because general statutes on fraud, malpractice, and assault don't adequately capture the violation. That they often lead to light consequences or no prosecution at all. This bill closes that gap here in South Dakota by clearly defining the offense when a provider knowingly uses their own or another's reproductive material without explicit written patient consent. It protects patients and children from the profound psychological and medical impacts. I urge do pass recommendation. Thank you for your time, and I'll stand by for questions.
Thank you, Representative Jorgensen. Any other proponent testimony? House Bill 1164.
We have some online.
Seeing none in the room, we'll move to online proponent testimony. And Mr. Wood, if you're available, please unmute and introduce yourself.
Thank you. Name's Josh Wood, Mr. Chair and members of the committee. I'm the executive director at Them Before Us. We're an organization committed to defending children's rights in the family. I'm here to ask you to vote yes on HB 1164. We're deeply grateful to Rep. Jorgensen and Senator Holst for introducing this legislation. There are only 14 states that have civil or criminal laws addressing this fertility fraud. South Dakota is not one of them. At least 50 doctors have been publicly accused of committing fertility fraud, and media reports would suggest that number is actually a lot higher. This is not a victimless crime. We recognize the profound violation experienced by women who discover that their own doctor has inseminated them with his own sperm without their knowledge or consent. We can't overlook the lifelong harm inflicted on the children conceived through this deception either. These are not abstract statistics. They are sons and daughters who discover decades later that they were conceived through what amounts to medical assault. Many describe a deep sense of betrayal, identity fracture, genealogical bewilderment, learning that the man who raised them is not their father, and that their biological father is the doctor their parents trusted. They often discover dozens of half-siblings, sometimes in the same city, sometimes the same school, sometimes the same social circles. Some, unfortunately, have even learned that they've unknowingly dated or nearly married a half-sibling. That's not a hypothetical. That has already happened. Victoria Hill was 39 years old when a DNA test revealed that her biological father was not the man who raised her, but her mother's fertility doctor, and she discovered that 22 half-siblings had been conceived the same way. Later, she learned that her high school boyfriend, someone she had almost married, was her half-brother. Had life taken a different path, she could be married to a sibling because of this deception. Victoria described trauma as the gift that keeps on giving as new siblings continue to surface. And they have to all face how they were conceived. Eve Wiley's story is similar. As a teenager, she learned she was donor conceived and began searching for her biological father. She eventually found a man she believed was her donor. They built a relationship. He officiated her wedding. Only years later, a DNA test revealed he was not her father, but it was her mother's fertility doctor. Her sense of identity being dismantled, not once, but twice. Beyond the trauma, emotionally, these individuals face serious medical consequences. Many grow up believing they know their family history, only to discover it was false. They miss critical screenings. They miss preventative care because they were given inaccurate information about their own genetic risks. Access to truthful medical history is not a luxury, it's life-saving. And yet in states without these laws, clear fertility fraud laws, justice is out of reach for these individuals. Doctors who father dozens, sometimes over 90, children through deception face minimal consequences. In some cases, they weren't even charged for doing the act of inseminating because no laws exist to address the crime. Without explicit protections, the children conceived through fertility fraud are left with lifelong consequences and little accountability. HB 1164 recognizes that these individuals are victims. It affirms that children have a right to truth about their origins, to accurate medical history, and to protect them from exploitation disguised as medical care. This question is not why now. Why now? The question is why this protection has not existed all along. Thank you for your time and consideration on this bill.
Thank you, Mr. Wood. Any other proponent testimony, online or in person? Seeing none, we'll go to opponent testimony. Any opponents to House Bill 1164? Aren't any, so the chair is back. We'll open this up to discussion or questions.
Any committee questions?
Madam Chair?
Senator Blanc.
Question for the Prime. Thank you, Representative Jorgensen, for being here.
Thank you.
My question is just to verify, 15 states have passed this legislation up to this point?
Madam Chair?
Go ahead.
14, I think it's 14 to 15.
14, 15 states,
Right.
okay. And Madam Chair, follow-up?
Go ahead, Senator LeBlanc.
Can you tell us what the penalties for conviction have been?
I can tell, well, Madam Chair, would it be okay if Josh talks about other states? I can tell you what's in this bill, but as far as other states, I think he might have a better feeling for what, or better information.
Sure.
Thank you.
Phone a friend. Mr. Wood.
Yes. So again, this will be offhand, so I can follow up with the exacts, but if I am recalling correctly, 5 years imprisonment, $5,000 fine, I believe was Florida, felony, 3rd-degree felony in Colorado, I believe 12 to 18 months in jail, $1,000 to $100,000 fine. Arkansas, I believe, was another one. Texas, but it all tends to be felony jail time and this type of fine as well.
Thank you, Mr. Wood.
Any other committee questions? Questions from any other committee member? Seeing none, we'll move on to committee discussion and/or action.
Madam Chair,
Senator Grove.
I move to pass.
Second.
So there's a motion by Senator Grove and a second by Senator Melhoff. Discussion on your motion?
Madam Chair, just very briefly, oddly, this has sort of been an issue that's sort of kind of what happened to me. Not that the whole how the people got pregnant and whatnot, but I was given up for adoption, and at the time that I was given up for adoption, they did not put on my birth certificate my native heritage, only my Black heritage. And so I, for my whole life, was looking for only a portion of my relatives. I didn't understand all that made up me until I was 50. And so there was this huge, they had all the words, but it was like a huge tearing of who I was. And I finally, just this year, through Ancestry.com and all that kind of stuff, have found like what makes me me. And so I can relate to these people not being connected to who they are, and just the utter betrayal that occurs when you realize that governmental entities literally participated in me not knowing my history. So this is a good bill. Thank you.
Any further discussion on the motion? Seeing none, those in favor of the motion do pass, say aye. Those opposed say nay. The secretary will call the roll.
Senator Blanc.
Aye.
Duhamel.
Aye.
Grove.
Aye.
Melhoff.
Aye.
Pischke, excused. Hulse.
Aye.
Kolbeck, excused. Madam Chair, we have 5 ayes, no nays, 2 excused.
Having received an affirmative vote of the majority of senators here, the bill is passed. And that will go to the floor with a do pass recommendation. Is there any problems with certifying that for the consent? Seeing none, that will be on the consent calendar. All right, moving on to our next bill. I see Representative Mortensen has not returned from the discussion happening in the committee hearing that I was just in. And so let's move on to 1234 if Representative Roby is in the room. We'll take that bill and then move back to the Representative Mortensen bill when he returns from the other conflicting committee hearing. Thank you.
Thank you, Madam Chair, members of the committee. Good to be here today. So HB 1234 is a pretty simple bill. It was suggested to me by, Matt Roby, representative from District 5, Watertown. An attorney in my district. In criminal and civil cases, attorneys have the ability to issue subpoenas. And it was long kind of understood or thought to be the case that that was also true in administrative contested cases. And there was a recent Supreme Court opinion in 2005 that found that without explicit authority, that is not the case in administrative contested cases. And so What this would simply do would be to add that attorneys have the ability to issue subpoenas in administrative contested cases. Thank you.
Further proponent testimony.
Good morning, Madam Chair, members of the committee. I'm Steve Siegel. I'm the registered lobbyist for the South Dakota Trial Lawyers Association. We too rise in support of House Bill 1234. It mirrors the rules of civil procedure in South Dakota. We think that's a good idea, and I hope you'll support it. Thanks a lot.
Further proponent testimony in the room? Seeing none, is there any proponent testimony online? Seeing none, okay, we'll move on to opponent testimony. Is there any opponent testimony in the room? Seeing none, is there any opponent testimony online? Seeing none, with that, we'll move on to committee questions. Questions from the committee? Any questions from the committee at all? Looking at one member in specific. Okay. All right. Seeing no questions, we'll move on to discussion and/or action. Yes, Senator Duhamel.
I move do pass House Bill 1234.
Second.
All right. We have a do pass motion from Senator Duhamel and a second from Senator Melhoff. Discussion on your motion.
No, it mirrors making everything uniform. I think it makes sense.
Any further discussion on the motion do pass? All right, seeing none, the motion is do pass. Those in favor say aye, those opposed say nay, and the secretary will call the roll.
Senator Blanc.
Aye.
Duhamel.
Aye.
Grove.
Aye.
Melhoff.
Aye.
Pischke, excused. Hulse.
Aye.
Kolbeck, excused. Madam Chair, we have 5 ayes, no nays, 2 excused.
All right, after receiving the majority of a members elect, with a do passes, motion passes. And House Bill 1234 will go to the floor with a do pass recommendation. Are there any problems with putting that on the consent calendar? All right, we'll do that one for the consent as well. Doing really well here, folks. Let's move on to 1066, Representative Fitzgerald.
Good morning, Madam Chair. Mary Fitzgerald, District 31, Lawrence County. It's an honor to be before you today. I am here on behalf of House Bill 1066, an act to revise and simplify provisions related to theft by a contractor, subcontractor, or supplier involving real estate. Soon you will hear why I drafted this bill and why it must be codified into law. This bill does 3 important things. First, it clarifies that when a contractor is entrusted with property or funds for the improvement of real estate and with the intent to defraud, diverts those funds for another purpose, that conduct constitutes theft. Second, it removes outdated and unnecessarily restrictive language that limits enforcement to specific payment mechanics. The core question in a theft case should be whether someone intentionally misused entrusted funds or whether the payment was, excuse me, I'm going to read that again. The core question in a theft case should be whether someone intentionally misused funds entrusted to them, not whether the payment was routed, labeled, or structured in a particular way. And third, this bill aligns penalties under this section with general theft statutes. This bill does not criminalize legitimate business disputes. It does not punish good faith withholding of funds for incomplete or defective work. It simply makes it clear that intentional fraud, taking entrusted construction funds and using them for something else, is theft. So essentially, House Bill 1066 is a modernization of South Dakota's contractor theft statute. It modernizes the statute from a rigid payment proceeds model to an embezzlement and intent to defraud theft framework, which is legally cleaner, more enforceable, and better aligned with criminal law principles. The current law nearly focuses on proceeds of payment and includes outdated phrasing. For instance, $500 was changed in the grand theft statute back in 2005. Grand theft is now $1,000. So part of the meat of this bill is outdated. It contains conditional language that complicates enforcement. As written, it's harder to prosecute intentional diversion of construction funds. You may ask why this legislation is necessary. Well, I'll give you another example, too. In many cases, a dishonest contractor will purchase materials such as shingles for a roofing project, charge those materials to the homeowner's project, and then that construction person will not pay that bill at Connex, for example. And so then that homeowner is left with having a lien put on their house because those bills were not paid. As a result, a lien is often filed against that homeowner. A little nervous here this morning, and I don't know why. But this law is necessary. It needs to be updated. It needs to be made enforceable. And so I'm going to sit down right now, Chair, and let a victim of one of these cases let you know what happened to her in Pennington County. Thank you.
Thank you, Representative Fitzgerald. Further proponent testimony. So go ahead, come up to the mic, make sure you turn on the microphone so it's green, tell us your name, tell us where you're from, and then tell us your story.
Good morning, everyone. My name is Larissa Mangione. I live in Rapid City. I'm a teacher, a small business owner, and I am the founder of a nonprofit called Native Voices, and we provide music lessons to Native Americans. My husband and I hired RMH Construction, owned by Ray Hughesby, out of Whitewood in February of 2024. We did do our due diligence. Mr. Hughesby had his contractor's license in the city of Rapid City. He had his business license with the state of South Dakota, as well as his South Dakota insurance for his business. Work began in June 2024. We paid Mr. Hughesby $26,411.84 for windows, $13,280.58 for countertops, $22,988.17 for kitchen cabinets. Mr. Hughesby didn't provide the items we entrusted him with the money for. We also discovered that he filed a fraudulent building permit with the town of Rapid City. The work ended and we discontinued the work with him in December of 2024 because we did not receive any of the items that we paid for. We contacted the Rapid City code enforcement, obviously. We contacted the city of Whitewood to file complaints. We filed complaints with Rapid City Police Department, Pennington County. We also filed complaints with the Department of Revenue as well as the Attorney General's office for, obviously, the misappropriation of funds. Nobody helped us. Not one person. In fact, when I called the Attorney General's office, they gave me many reasons. One of the top reasons was there weren't, quote, enough complaints. There weren't a lot of people. Apparently our one complaint wasn't enough, and as well as they blamed all of you. They said it was the Senate and the House of Representatives' fault, and from there, some of you I actually have talked to on the phone. My husband and I emailed every one of you with our case as well. This further went on to arbitration as per the contract we had. The arbitrator did rule in our favor. My husband and I, between paying the American Arbitration Association and our attorney's fees, had to pay and be out an additional $10,000 just to help our case. The contractor in question, what he did instead was he liquidated his assets in the state of South Dakota. He, his ex-wife, and their children moved to New York State, where he is now promoting his new wife's, on social media, his new wife's OnlyFans account.
I think at this point, let's try to keep it to the bill. And also let's ensure that, I let you kind of talk about this individual, but let's just refer to them as the contractor at this point.
Sounds good.
Thank you.
What I think is very upsetting about this situation is my husband and I saved for years. We are not the only ones who are alone. In order to finish our project, we had to take out a home equity line of credit. This is absolutely insane that somebody who committed this kind of fraud and this kind of theft is not being held accountable. This is not a Democrat or a Republican issue. This is a South Dakota citizens issue. We all have to protect those of us who are good people. We live in an awesome state, and this is a way to protect those who have been victimized. Thank you.
Further proponent testimony in the room? Any proponent testimony online? Oh, we got one in the room? Okay, thank you.
Terribly sorry, Madam Chair. My reflexes are a little slow this morning. I apologize. Grant Flynn from the South Dakota Attorney General's Office. I know there's other folks online that I want to make sure you get to listen to. So I just want to take a moment to say that the Attorney General's Office supports this bill. It will, as the sponsor said, make these laws more enforceable and help some of these folks who are taken advantage of by unscrupulous business people. So we appreciate your support. Thank you.
Further proponent testimony. Thank you for your quickness this morning, Mr. Erickson.
Thank you. Good morning, Madam Chair, members of the committee. Eric Erickson with the State's Attorneys Association. We appreciate the sponsors bringing this bill. We run into these unfortunate and terrible circumstances more regularly than we'd appreciate. We appreciate the sponsors bringing this bill and would ask for your favorable consideration.
Further proponent testimony in the room.
Morning, Madam Chair. Tim Walberg from District 8. Nice to see you all so bright and early this morning on our last day before we go home. I just want to offer a quick me too and just say intent doesn't have to start in the beginning. The intent to defraud a customer can happen anywhere during this process with this money. So I hope you all vote green and have a great day.
And just make sure that you sign in electronically. Thank you. Any further proponent testimony in the room? All right, we'll go online to proponent testimony. No proponent testimony online. So we'll move
Madam
on.
Chair.
Oh.
Sorry, can you hear me?
1 second here. We're just getting your system pulled up.
Okay.
All right. We just see a phone number here. So can you announce yourself and if you're a proponent or an opponent?
Yes, thank you, Madam Chair. I'm Dan Nelson, State's Attorney in Brookings County, and providing proponent testimony.
Great. Go ahead, Mr. Nelson.
Thank you, Madam Chair. Good morning, Senate Judiciary, Madam Chair. Rising in support of House Bill 1066, I want to thank the good Representative Fitzgerald for bringing this bill. This bill is about protecting homeowners, protecting those that enter into these construction agreements. This bill is really a cleanup bill. As Representative Fitzgerald talked about, it does update a lot of the language in our theft statute, specifically lines 18 and 19, codifying the degrees of theft between Class 2 misdemeanors, Class 1 misdemeanors, and of course, getting into our grand theft type statutes. So that was an important part of it. But also picking up where Representative Walberg talked about, a lot of times in these types of cases, the intent to defraud is not always on the front end. That misappropriation sometimes happens in the middle or end of a project. And what this bill does is it protects that homeowner during all three phases, beginning, middle, and end. And I think it's an important piece of legislation. I think the victim who talked before I did, I think really kind of shows the Senate Judiciary just sort of how these crimes can impact those individuals in a lot of different ways financially. And sometimes there isn't a lot of recourse, but this bill provides a better enforcement mechanism that I think says to the contractor, you cannot under any circumstances, appropriate the money that was given to you on that specific project for something else. And that's what I've seen in my experience as a prosecutor, where these contractors get this large sum of money. And then when they see that large sum of money, there's a big temptation a lot of times to start appropriating that money outside of the scope of the project. And it often leaves the homeowner holding the bag. So I think this is important legislation. I think it cleans up a lot of some of the outdated areas of the law and makes us more in line with the modern theft statutes that we currently have on the books and protects the homeowner from these tragic circumstances. So again, I would encourage your yes vote on this and move it to the floor. Thank you.
Thank you, Mr. Nelson. Is there any other proponent testimony online? Seeing none, we'll move on to opponent testimony. Is there any opponent testimony in the room? Mr. Siegel? Yes or no? Okay. All right. Seeing no opponent testimony in the room, we'll move on to opponent testimony online. Seeing none, we will close public testimony and move on to committee questions. Are there any committee questions on this bill?
Madam Chair.
Senator Grove.
For the victim of this, I'm sorry, so bad with names.
Come up to the microphone.
Yes.
And then reintroduce yourself so that the people listening online can know who's talking.
My name is Larissa Mangione. I live in Rapid City.
Madam Chair. Thank you for sharing your story. I am sorry that that happened to you. Can you explain when you went to, you said that you tried to file through kind of the avenues that one would think you could file through with the police and the Attorney General's office and all of that. Can you, I know that you said that it was kind of sounded like a legislative thing, but were there no other laws currently in place that could assist you in this area?
According to law enforcement and whom we talked with, they said no. There was no way they could help us, even though we have piles of documentation to support what we were stating. It's been a very frustrating process.
Any further questions at all? Sure. Senator Blanc.
Ms. Mangione?
No.
Yes.
Thank you. Thank you again for being here. I just have a quick question. What was the amount of money that you were defrauded of?
Ms. Mangione, just restate your name. Thank you.
Larissa Mangione, thank you. Approximately $53,000.
$53,000.
Yes.
And Madam Chair, one more quick question.
Go ahead, Senator Blanc.
Could you list the agencies once again that you tried to receive help from, but were weighed in the balances and found wanting, it sounds like?
We filed complaints with Rapid City. We filed complaints with the City of Whitewood. We filed complaints with the Attorney General's office, Pennington County, Rapid City Police Department, as well as the Department of Revenue.
Very good. Great testimony. Thank you.
Thank you.
Any further questions? I actually have one, and it would be either, I would say probably for the prime or potentially for Mr. Grant Flynn from the Attorney General's office, or Eric from the State's Attorney's office. So when you look at 44-19-13, one of the things in this statute that's being crossed out says it's not a violation of this section to withhold funds from a contractor, subcontractor, pending the completion of the final approval of work. Why does that need to be crossed out? Wouldn't that be helpful to leave that in as these two parties handle this situation, this matter? Why do we need to remove that from the law while updating this? Would really say anybody in the room that would like to answer that question for me. Stumped them all. If the prime wants to kind of try her hand at it. Go ahead.
Mary Fitzgerald, District 31, Lawrence County. We're trying to make this bill as simple as we can, and we're concentrating on the intent because with theft laws, the main element of the crime is intent. And so that's what we focused on with this bill. And so that's why all these other unnecessary things, other contingencies were taken out. And I don't know if Dan Nelson's still on file. He might be a person that could answer that better than me. But we're trying to make it as simple, as easy as we can so that it's more enforceable and is written to try to help out the victims of these crimes.
Madam Chair.
Let Grant Flynn try to answer my question, and then I'll go to you, Senator Grove.
Madam Chair, Grant Flynn from the Attorney General's office. And I'm just going to echo what I believe Representative Fitzgerald was saying, that I think this is about simplicity, right? Sometimes when you include an exception in a statute, then it sort of shines a light on it, right? And it's sort of, this statute is intended to address contractors' negative behavior, not customers' negative behavior. So if you have anything in the statute that references the customer, then even if it's an exception, I think it risks causing some kind of lack of clarity. Why are we addressing, these two different issues if this statute only has one purpose? So I think that would be one explanation for why they would make that change, is to narrow and center the focus of what this statute is trying to accomplish.
Can you just stay there for 1 second? So just to confirm, there would be somewhere else in the law that explicitly would give the right of a homeowner to withhold funds if the contractor didn't provide services before, because like what I'm concerned about, if we remove this from this section of law, more homeowners dealing with this issue are going to be sued by contractors saying, well, they didn't pay me. So I just want to make sure that we're not taking away a right of a homeowner, or taking away at least a line in a statute to say, you can't sue me, I'm withholding these funds for a reason. Does that make sense?
Madam Chair, Grant Flynn from the AG's office. It absolutely makes sense, and I fully understand. And I think that your argument absolutely has merit. I think the protections that you're talking about would lie in the civil portion of the code, because those should be civil actions, right? You're talking about a contract dispute at that point. I imagine there's a factual scenario where you could say that a customer has committed a crime by not paying their contractor, but for the most part, law enforcement is going to say that's a civil matter, and they need to take that to court and have a judge determine what work was done and what needs to be paid. And so I think that's the distinction that we're drawing here, is by removing this from the criminal code entirely, we're recognizing that instead of having a specific exception that says this isn't a crime, we're just going to take it out so the implication isn't even there.
Got it. And Mr. Erickson, do you have a citation or a statute anywhere that would talk about that you're allowed to withhold funds given these circumstances? Or I guess you said can you answer my question as well? Thank you.
Madam Chair, Eric Erickson, States Attorneys Association. Much like I think doctors don't like people going on WebMD, I'm a little cautious because I haven't looked at the whole chapter and the civil side, so I don't know. I wouldn't see a problem necessarily with leaving that in there to just have that clarity in it, but I think a lot of times that would be a civil matter, right? As far as if a contractor came in, did a bunch of work, and you didn't pay him, you'd have unjust enrichment type claims and those things on the civil side. I don't know as if it harms it if that language was in there, but again, I haven't read the full chapter, so I'm a little hesitant to make that opinion.
Okay. Any further questions from the committee?
Madam Chair.
Go ahead, Senator Grove.
So from what I understand is it Nielsen or Nelson that's online? It was stated that it's the intent, and intent can be any time in the process. So if I realize in the midst of this that this person is not spending my money in the way that we had contracted to spend, by removing this, does that put me in a situation where I am liable to pay, even though I know that things aren't going the way they're supposed to go. Did we just remove the teeth for the homeowner? And it doesn't sound like people in the room are quite sure. So I'm just wondering if the one on the online knows?
Mr. Nelson, would you like to take that question?
Yes, I can try. I unmuted between parts of your question, so, but I assume you're talking about lines 10 and 11.
It starts on line 15. And
Okay, Madam Chair. Okay, part of the question I thought I heard Senator Grove asking was in regards to lines 10 through 12, but are you also asking my opinion on lines 16, 17, and
Yeah, I mean, I think I'm going to try to rephrase the question, and maybe Senator Grove can tell me whether or not I'm picking up what she's putting down or not. But the question is essentially, what point in the process is intent formed, or how would you prove intent to defraud in this situation? And would a homeowner still be required to pay the contractor even after the point of the realization that there was an intent to defraud? Is that correct, Senator Grove? That's correct.
did she confirm that was the question?
Yes.
Sorry. Okay. Yeah, so what I would tell you is that this statute allows for a prosecution if there's a misappropriation of those funds under the deception definition. So in line 11, where it talks about the definition of deception in 22-30A, so the state would have to prove that the misappropriation, whether it happened at the beginning, the middle, or the end of the project, if there was a misappropriation of funds done under the deception definition, then there would be a basis for prosecution. So that would be the first part of the question. The second part is no, the homeowner would not have to continue paying the contractor after that deception or that misappropriation by deception had been discovered. So if that answers your question.
Madam Chair, that answers my question. Thank you.
Any further questions from the committee? Seeing none, we'll move on to discussion and/or action.
I move do pass House Bill 1066.
We have a motion do pass from Senator Duhamel, a second from Senator Grove. Any discussion on your motion?
I like how it's written. I think it's very narrow focus, protecting homeowners in all phases of the project and updating our theft statutes. Important, and I'm sorry to the homeowner as well that this happened, and hopefully we can put some teeth in so we have some remedy for future.
Any further discussion on the motion? Quiet bunch today. All right, well, with that, we have a do pass motion. Those in favor say aye. Those opposed say nay. Secretary will call the roll.
Senator Blanc.
Aye.
Duhamel.
Aye.
Grove.
Aye.
Melhoff, excused. Pischke, excused. Hulse.
Aye.
Colbeck, excused. Madam Chair, we have 4 ayes, 3 excused.
After receiving a majority of the members elect, the do pass motion passes, and we will send House Bill 1066 to the floor with the do pass recommendation. Does anyone have any? Okay, we don't have a quorum at this point. We only have 3. Okay, we'll just hold off for a second before I make any. So we'll be at recess for a hot second while we don't have a quorum of members. Short string today, folks. All right, now that we have a quorum in the room again, does anyone have any objections of putting this on the consent calendar? No. Okay, we're going to certify that for the consent. Now we're going to move back a little bit in the agenda and go to House Bill 1179, which we heard testimony for on Tuesday. And I believe that Representative Mortensen has an amendment, and so I'll let him take the floor.
You bet. Thank you, Madam Chair. Will Mortensen, representing District 24, which is Central South Dakota, presenting House Bill 1179. There is an amendment, 1179A. If someone would move it, I'd be happy to speak to the amendment.
Has the amendment's been posted? Okay.
I would move 1179A.
All right, so we have a motion from Senator Duhamel, a second from Senator Blanc. Any discussion on the motion to amend? Seeing none, those in favor of amending say aye. Aye. Those opposed, nay. The bill is amended. Go ahead, Representative Mortensen.
Thank you, Madam Chair. Took the comments and feedback of this committee, particularly pertaining to making sure that we weren't incurring unnecessary cost and having fees applied every time these are sent out initially, but only when the actual burden of filling out the longer form disclosure is done by that employer. Took that feedback, created the mechanism really that was proposed by Mr. Smith, and then brought the fee amount from 50 down to 40 to really reflect what inflation has been over this period. And so I will stand by for any questions and other testimony.
You might as well just stay in your chair, Representative Mortensen. Oh, we've got other testimony. Okay, go ahead.
Morning, Madam Chair, members of the committee. Justin Smith, attorney from Sioux Falls, registered lobbyist for AAA Collections. I want to thank Representative Mortensen heartily for working with me on this. Thank the Retailers Association as well, which was supportive of the original version of the bill. This is intended to be a compromise, as Representative Mortensen indicated. It's intended to make sure the businesses who are actually doing the garnishments are getting a higher fee than the one set in 1998, in this case $40, while at the same time saving the debtors money where there is just no ability to collect from a particular garnish or particular business because that person no longer works for them or what have you. So really, really appreciate the good representative for working with us on this. We would ask you to please support the bill as amended. Thank you.
Thank you. Any other testimony in the room? Seeing none, we're going to go to if there are any committee questions about the amendment at all. I have one just brief one for the prime. I got a couple emails from other collection agencies, and a couple of them said that they didn't want the amount to be over $30. Can you just describe kind of how we landed at 40 since we last met?
Thank you, Madam Chair. Yeah, like I say, it was set in the 1990s, and if you wrote inflation, it would be over this amount. But, when we looked at it, we thought about the burden of the staff time on those businesses, and again, when you heard Mr. Abraham, and then we had some small businesses on the House side that came in and testified to this as well. But now it really does almost exactly reflect the ratio of minimum wage and the number of hours then to now. And so I think this is appropriate. And one thing about it, you don't want to put the legislature in the position of having to update these every 5 years. I think every 25 years is just fine. But then when you do, you got to actually true it up and then over the next period of time. So on these numbers, I bet if you asked 100 people, you could 100 different numbers. I had one and then compromised down with Mr. Smith and his clients. And I think this is something that achieves enough of the goal that I was seeking that it's still acceptable.
Great, thank you so much. All right, seeing no further questions. Oh, we have another one. All right, Senator Blanc.
Representative Mortensen, the chair asked the question that I had. My actual question was, were any lesser fees discussed?
Okay. Higher fees and lesser fees were discussed, and so the answer is yes. A lot of different versions of this kind of got worked through after we got the feedback from these folks, and thank Mr. Smith for being open to different mechanisms. And then the retailers folks got their eyes on it too, on the mechanism, and kind of understand that there's some give and take really of on the business owner's side here too.
Good, Madam Chair. Thank you for reading, Madam Chair. Thank you for reading my mind on my next question is who was involved in your discussions?
Madam Chair. Yeah, so this whole bill got brought to me by some small business owners here, readily restaurant owners and these kind of folks. And so Mr. Smith and his clients were involved in this, and then a couple of different folks from the retailers who were be honest, that's the group that represents the largest number of small business owners here. So they kind of worked this over. I would say that their preference in this was largely aligned with mine, which is making sure that when our statutes put a burden on a private party, that it be compensated, frankly. So, but anyway, those were the groups that worked through it, both on the mechanism, understanding there's going to be instances when people are going to have to fill out one of these and say, hey, this person doesn't work here. Now they don't get it. You know, there's no fee at all there now under the mechanism we're putting in, but we were comfortable with that. I mean, a couple of them are attorneys who have been business law attorneys longer than I have. They know this system a little bit better, and they said, yeah, this would work. I mean, it really, it's the right way to put the compensation there when there's an actual time burden. So anyway.
Thank you for seeing the wisdom in a multitude of counsel. Appreciate that. Thank you.
All right, seeing no further.
I have one
we
question.
do have a question. Senator
Sorry.
Grove.
No, a question for Mr. Smith. AAA. Madam Chair. I know this is very simplistic, but I am going to ask anyway. So the procedure now, what does it look like?
Madam Chair. Senator Grove, thank you for the question. The procedure now is under the statutes under Chapter 2118. The garnishee, or the plaintiff, which would be AAA Collections, my client, will send out a summons, garnishment affidavit, and an affidavit of no liability, the three documents, to the garnishee, which is the business that hopefully has the person working for them. Right now, they send a $15 check to that business, regardless. And then that business will return one of the two forms, either the very short form that says denial of liability, this person doesn't work here, we have no assets we can garnish, or two, the longer form where they go through the calculation and they agree, because of being compelled by the law, to garnish the person's wages. So the business can cash the $15 check regardless of whether they do 5 minutes of work in filling out the short form or the long work of not only completing the extensive form, but then doing the garnishment over time. And when this bill passes, what will happen is those forms will still be sent. That process will remain the same. The check will not go with those initial forms. If the business either doesn't respond or sends back the short form that says no liability, then that's the end of it. They don't get the check, and therefore the debtor saves money on that one. But if the business returns the longer form and says, yes, they work here, yes, we'll garnish, then immediately the collector will send out the $40 check to them.
All right, seeing no further questions from the committee, we will move on to discussion and/or action for House Bill 1179 as amended. Senator Duhamel.
I'd move House Bill 1179 as amended.
Second. And so we have a motion by Senator Duhamel, a second by myself, Senator Hulse, as do pass for House Bill 1179 as amended. Any discussion on your motion?
I think it's a wonderful compromise by all parties. More targeted, great bill.
All right, any other further discussion? Senator Grove.
I am struggling with the $40 fee. I have been told that's high. I do like the compromise. I do like that they came together and got it done. I just am struggling with that fee. So I don't know what I'm doing.
Any other discussion on the motion? Well, I just want to clarify that the fee of $40 is sent to the company. And while that is included eventually in the person's, being garnished, oftentimes they're being garnished because they, have debt or child support or other things. And so I just wanted to make sure that we understood that that was part of the process, and it's being sent to the business owner because they're having to be put in a tough spot for having to take all of this on. So with that, Secretary, please call the roll on the do pass motion 1179. Those in favor say aye. Those opposed say nay.
Senator Blanc.
Aye.
Duhamel.
Aye.
Grove.
Aye.
Melhoff, excused. Pischke, excused. Hulse.
Aye.
Colbeck, excused. Madam Chair, we have 4 ayes, 3 excused.
All right, after receiving the majority of members elect, the do pass as amended motion passes, and will send House Bill 1179 as amended to the floor with a do pass recommendation. Any problems with putting that on the consent?
I would prefer we talk about it.
All right, so we won't put that one on the consent calendar. All righty, well, now we will move on to House Bill 1126. We'll take proponent testimony.
Good morning, Madam Chair. Tim Walberg, House Representative from District 8 in Madison. Today I bring you House Bill 1126. House Bill 1126 is, I would like to term it a little bit of a clarification, try to clean up this bill as there's some language that was in here that noted it was kind of left out. So what 1126 is seeking to do is identify the 5th, 6 subsequent convictions on DUI. In the statute, 3223.4.9, it states if a conviction of a violation of 3223.1, which is DWI, for a 6th or subsequent offense, and the person has at least 5 convictions of 3223.1 occurring within 25 years of the violation being charged, and at least 2 prior convictions occurring within 10 years, the violation is an aggravated offense and the person is guilty of a Class 4 felony. This is where the issue comes in. If a person is convicted of an aggravated violation of 3223.1 and the person has at least 6 convictions of 3223.1 occurring within 15 years of the violation and being charged, the court must sentence the person to at least 6 years. This statute covers the 6th conviction, but it does not cover the 5th. We need to identify the 5th conviction is what we're trying to do here. I will stand by for questions, but Dan Nelson from the Brookings County State's Attorney can also help give some better clarification from the attorney side.
All right, we'll take further proponent testimony. We want to go to online proponent Nelson.
Yes, Madam Chair, Dan Nelson, State's Attorney, Brookings County. I want to thank the good representative for bringing this bill. It's really a clarification bill. If some of the members of Senate Judiciary recall, a few years ago, there was a series of bills that had been passed implementing the mandatory minimums for DUIs. And this was, I think, maybe just an oversight on part of the legislature when those laws were passed. If we look at line 9 on House Bill 1126, we're removing the word 6 and just placing it at 5. And the reason we're doing that is because right now there are mandatory minimums for a 4th offense, a 5th offense, and a 7th offense, but there's no mandatory minimum for a 6th offense. And so all we're doing in this bill is just making it in line with current statutes. So I'll just repeat that. There's a mandatory minimum for a 4th offense, a 5th offense, but not a 6th offense. The way the current law reads is there's a mandatory minimum for a 7th offense, but not a 6th offense. And so what is happening is there are a number of cases here in the last few years across South Dakota where judges have looked at this law as it's currently written and have not imposed a mandatory minimum for those that have been convicted of a 6th offense within that 15-year period. And so we have judges imposing mandatory minimums for 4th, 5th, and 7th, but not 6th. And so I think that kind of flies in the face of the legislative intent of the legislature a few years ago when those laws were passed. This bill just clarifies that, makes it more in line with, I think, what the legislative intent was by just removing the word 6 and putting 5 there in line 9. So would encourage your support on this and move it to the floor. Thank you.
All right, is there any further proponent testimony in the room?
Good morning again, Madam Chair. Eric Erickson with States Attorneys Association. We think States Attorney Nelson put it rather well, but this is a priority for our other states' attorneys, and just want to mention that this has the full backing of our group. Thank you.
Any further proponent testimony in the room? There you go, Mr. Flynn.
Good morning, Madam Chair, members of the committee. Grant Flynn from the South Dakota Attorney General's Office. We believe this is the definition of a cleanup bill. It brings, as State's Attorney Nelson said, the statute in line with what the intent was of this original legislation, and certainly addresses very concerning behavior. Someone who's repeatedly been driving intoxicated, which causes significant dangers on our roads, and we would appreciate your support. Thank you.
Thank you, Mr. Flynn. Further proponent testimony.
Thank you, Madam Chair. I am not going to run. Jenna Severin, South Dakota Police Chiefs Association. Just want to thank the prime sponsor for bringing this bill. All of the prior proponents did an excellent job explaining what the bill does, so we're just up here as a me too. Thank you.
Thank you, Ms. Severin. Any further proponent testimony in the room? Seeing none, we'll move on to opponent testimony. Seeing none in the room, we'll move on to opponent testimony online. Seeing none, we'll close the public testimony portion and move on to committee questions. Any questions from the committee? All right, seeing no questions, we'll move on to discussion and/or action. Senator Blanc. We have a do pass motion from Senator Blanc and a second from Senator Duhamel. Discussion on your motion, Senator Blanc.
Nope.
Any discussion on the motion? All right, seeing no discussion, those in favor of House Bill 1126 and the motion to do pass, those in favor say aye. Those opposed say nay. The secretary will call the roll.
Senator Blanc.
Aye.
Duhamel.
Aye.
Grove.
Aye.
Melhoff, excused. Pischke, excused. Hulse.
Aye.
Colbeck, excused. Madam Chair, we have 4 ayes, 3 excused.
After receiving a majority of the members elect, the do pass motion passes, and we will send House Bill 1126 to the floor with a do pass recommendation. Any problems with certifying that for the consent calendar? Seeing none, we will put that on the consent calendar. And with that, I will entertain a motion to adjourn.
So moved. Second.
All right, we have a motion to adjourn by Senator Duhamel and a second by Senator Blanc. Those in favor say aye. Aye. Those opposed? All right, we are adjourned.
SDPB brings South Dakotans together, telling the stories that unite small towns, big ideas, and the people who make our state shine. Good, useful, and full of wonder. SDPB. SDPB shares the voices and experiences of South Dakotans, preserving our stories, our culture, and our sense of place. SDPB, good, useful, and full of wonder. As South Dakota's public media network, SDPB serves everyone with transparency, integrity, and commitment to open access. Good, useful, and full of wonder. SDPB. SDPB helps shape South Dakota's future by educating, informing, and inspiring the next generation of thinkers, leaders, and creators. SDPB. Good, useful, and full of wonder. SDPB serves South Dakota through an interconnected communication system that is on 24/7, 365. The first place for Amber Alerts, public safety announcements, and EAS messages. SDPB keeps public servants and citizens informed. Good, useful, and full of wonder. SDPB. SDPB brings you closer to your government. With gavel-to-gavel coverage of the South Dakota legislature and in-depth reporting from peer. Good, useful, and full of wonder. SDPB. From early learners to lifelong students, SDPB inspires curiosity through trusted educational programs and resources for every stage of life. Good, useful, and full of wonder. SDPB. When South Dakotans need reliable information, SDPB is there providing updates and coverage that keep our communities safe and connected. Good, useful, and full of wonder. SDPB. SDPB celebrates South Dakota's student athletes with live coverage of SDHSAA state championships, sharing the excitement of hometown heroes. SDPB. Good, useful, and full of wonder. From choir to debate to theater, SDPB shines a spotlight on South Dakota's talented students through SDHSAA All-State Fine Arts programming. Good, useful, and full of wonder. SDPB. Every day, SDPB connects South Dakotans with stories that inform, inspire, and bring us together. SDPB, good, useful, and full of wonder. SDPB is your home for fact-based journalism, connecting South Dakotans with news they can trust and stories that matter. Good, useful, and full of wonder. SDPB. From children's programs to in-depth documentaries, SDPB sparks curiosity and lifelong learning in every South Dakotan. SDPB. Good, useful, and full of wonder. SDPB brings South Dakotans together, telling the stories that unite small towns, big ideas, and the people who make our state shine. Good, useful, and full of wonder. SDPB. SDPB shares the voices and experiences of South Dakotans, preserving our stories, our culture, and our sense of place. SDPB, good, useful, and full of wonder. As South Dakota's public media network, SDPB serves everyone with transparency, integrity, and commitment to open access. Good, useful, and full of wonder. SDPB. SDPB helps shape South Dakota's future by educating, informing, and inspiring the next generation of thinkers, leaders, and creators. SDPB. Good, useful, and full of wonder. SDPB serves South Dakota through an interconnected communication system that is on 24/7, 365. The first place for Amber Alerts, public safety announcements, and EAS messages. SDPB keeps public servants and citizens informed. Good, useful, and full of wonder. SDPB. SDPB brings you closer to your government. With gavel-to-gavel coverage of the South Dakota Legislature and in-depth reporting from Pierre. Good, useful, and full of wonder. SDPB. From early learners to lifelong students, SDPB inspires curiosity through trusted educational programs and resources for every stage of life. Good, useful, and full of wonder. SDPB. When South Dakotans need reliable information, SDPB is there providing updates and coverage that keep our communities safe and connected. Good, useful, and full of wonder. SDPB.